Good morning, everybody. Thank you so much for being here. This is exciting, and welcome on this bright, actually quite pleasant day here in Dallas, Texas. We certainly enjoy the February weather much more than we do the July weather, and so you're certainly benefiting from that. But welcome to the SMU's 20th Intellectual Property Symposium, and which is a big deal. And we want to provide a special welcome to some of our guests here today. We have United States Patent and Trademark Office, Texas Regional Director, Hope Shimabuku, who's one of our graduates. We're glad to have her here. We've got Professor Swan Tao Win, who actually taught here for the school at SMU for 10 years. We've got Professor Keith Robinson. Keith also taught here for a number of years, about 10 years. Trying to get both of them back. We're going to see how we do. We've got Judge K. Nicole Mitchell, who is a magistrate judge for the U.S. District Court for the Eastern District of Texas. We have Judge Stacy White, lead administrative patent judge, patent trial and appellate and appeal board. And we've got Cynthia Lynch, who is the acting deputy chief administrative trademark judge and trademark trial and appeal board, as well as Brad Newberg, Copyright Claims Officer from the Copyright Claims Board. So if you could join with me in welcoming these guests with us, we're grateful, and so many more as well. So as Dean, I have the delight really to highlight many of the strengths that we have at our wonderful institution. And I think many people are often just amazed at what we have to offer in lots of different fields, and particularly within the intellectual property field. And I want to just give you a couple of those highlights now. And so also in technology as well. And so our IP, technology, law, and programs, repeatedly earn A and A+ grades from Pre-Law Magazine. But we're certainly not resting on our past accomplishments. And it is one of the priorities that we have at the law school, certainly something that I have been focused on since I arrived as dean 18 months ago, is deciding and making decisions regarding how we can continue to draw upon these strengths. And we are situated within, as you know, a thriving city in Dallas, Texas, in the Dallas-Fort Worth area that provides many opportunities for our graduates and our professors and certainly our alumni. And we are tapping into many of those strengths and really preparing the next generation of lawyers to bring to pass and to work towards different rules of law and other types of practices that will support this growing trend of innovation within our area. So we have invested, for example, in a tenure track professor, Sari Mazurko, who is actually here on the stand today, who from Stanford, and she focuses on trademark law and internet law. And so we're very excited to have her here. And so this is her first year with us. We also just hired a new professor, Shanice Shisha, who is coming from Harvard, and he's going to be focusing on copyright law. And beyond these tenure track faculties, we also hired Candace Walter into a full-time position to run our small business and trademark clinic. And these new faculty members are already going to join a very robust and accomplished group of tenured faculties and adjunct faculty members that we have writing and teaching in the areas of intellectual property and technology law. So for example, as you know, we have David Taylor, who focuses on patent law, who's been here for a very long time. Somehow we were able to woo him out of private practice, in which he's still in demand, in many ways, to be able to join us at SMU. We have Nathan Cortez, who focuses on health technologies. We've got Carla Reyes, who is focusing on artificial intelligence and cryptocurrencies and blockchain technologies. Megan Ryan, who focuses on science and the law, and Orly Mazur, who focuses on technology and tax law. And as I travel around the country, people come here, they often comment on just the wonderful people that we have thriving in this particular area. And of course, they are all affiliated with the TIE Center in many forms. And beyond that, we have an accomplished group of adjunct faculty who teach a variety of advanced courses. And they include courses like intellectual property, international intellectual property. We have patent law. We have trademarks, copyright, trade secret misappropriation and business torts, patent litigation, patent prosecution, trials at the patent office, intellectual property licensing, patent law and institutional choice, got franchising and distribution law. We have international franchising and distribution law. We have race and intellectual property patent clinic. We've got a trademark clinic, a small business clinic, and artificial intelligence and the law. And coming from the University of Florida Levin College of Law, which I thought had a robust, offering in terms of these wonderful intellectual property classes, I can say that Florida pales in comparison. Sorry to Elizabeth Rowe, we were there together. We were just talking about her. She's at University of Virginia now, but it pales in comparison to what we offer here. So we're very proud of that. And just a couple more thoughts, and then we'll turn it over to David Taylor, who will give some other announcements. But we are, one of the reasons why our students come to SMU is because of our placement rate. I mean, we have a placement rate that's around 98% in full-time, long-term, bar passage required, or JD Advantage positions. That's 98%. And that's in part because we have such a thriving economy. We have such a robust curriculum. We have such a terrific career services team, who I'm looking at one of those, people right now. We have such a great, team that works with these individual students to help them to pursue their dreams. But many of these individuals enter into intellectual property, science, and technology fields because they are offered here and we prepare them so well. In part because we have an experiential education program. Our clinic program it was established 75 years ago. So we have the second longest, long-standing clinical education in the program that includes things like patent and trademark prosecution type clinics. So we're very happy about that. We also have, and I'm wrapping up here, we have really proud of what we have a corporate counsel externship program that really is unmatched in this country, in which we place about over 100 sometimes approximating 120 people per year. These are students in corporate counsel externship opportunities at some of the largest companies in the country, the Fortune 500 companies, including like Texas Instruments and others that often have a patent and technology focus. And so those individuals, those students that participate in that really benefit in many ways, but I'll just focus on two. One is that when they practice in large firms, when they practice in patent law litigation firms, they understand what the client wants. They understand the client, they understand the client needs. And second, as they can transition into those wonderful opportunities after practicing or sometimes directly out of law school. So it helps us with our placement rates. And then the last thing I'll say is that we continue to place our graduates in clerkship opportunities, including federal clerkship opportunities at district courts, at the Federal Court of Appeals, in which that also provides many intellectual property opportunities for our students. And so grateful that you're here to see some of the things that we offer at SMU Law. We're very proud of David and Taylor and many others who have really helped to establish such a strong program in intellectual property, technology, and law. And this is just one of the many illustrations of that. And so with that, if you would join with me in welcoming, you all know David Taylor, professor of law here at SMU. Please join me in welcoming him to the podium, and he will provide some other additional welcoming remarks and instructions.
All right, and just so you know, Dean Nance is a great dean, and I'm not biased, even though I served on the dean search committee that ended up recommending him. So anyway, but he's doing a great job here at the law school. So yeah, welcome to our conference. I'm glad you're here today. We have a great program. I think you know that, but it's going to be wonderful. Let me just highlight, right, we're at SMU, but this is sponsored by the Tice Center for Law, Science, and Innovation. It's a great center. I'll talk a little bit more about it later this morning, actually. But we do all kinds of programming, and this is just one of the things that we're doing. And I would encourage you to follow us on social media, get on our email list and find out about what else is going on. This symposium is our 20th symposium. And so we're happy to continue the tradition of this particular symposium. And today we're going to focus on intellectual property in Texas. And so various panels are going to, it's really two themes today. Our 20th symposium, so this panel in particular is going to look back over kind of the last 20 years of developments in intellectual property law and kind of forecast and look towards the future as well. And then other panels will focus more on kind of changes in the last 20 years in practice in intellectual property in Texas in particular. We have a stellar lineup of topics and speakers. We'll just jump into it here, but let me introduce our moderators. I'll be your MC today. I'll introduce the moderators, let the moderators introduce the panelists. So to moderate our first panel, we're going to welcome Matthew Hangay. He serves as the Assistant General Counsel and Senior Vice President of Bank of America. He earned his undergraduate degree, one of his undergraduate degrees in chemical engineering. What was the other one?
Economics.
Economics, and which is actually really helpful for intellectual property. Intellectual property is an economic-based theory. Anyway, so I could go on, but chemical engineering and economics from Rice University and his law degree from Harvard Law School. His practice experience includes time at Baker Botts here in Dallas, as well as at Alcon in Fort Worth. At Bank of America, he's responsible for directing the company's patent strategy, patent portfolio, and IP litigation. With that long introduction, welcome, Matt. Thank you.
Thanks, Andy. Yeah, so I started Baker Botts and spent the last 20 years here in Dallas. I've been in Charlotte for a year and a half, and when David asked me to do this, I jumped at the opportunity to come back. So it's a bit of a homecoming for me too, like several of our panelists here. So like David said, we're going to cover IP over the last 20 years. We've got an hour to do that. So buckle up. It's gonna be quick. But let me introduce our panelists first. The dean kind of already told you a little bit about them, but I'll brag on them a little bit more. So to my left, we've got Keith Robinson. Keith is a professor of law at Wake Forest University School of Law in Winston-Salem, North Carolina, near me in Charlotte. He researches how legal institutions govern emerging technology and how artificial intelligence may impact obtaining U.S. patents. Professor Robinson has a BS in electrical engineering and a JD, both from Duke University. After law school, he worked at the law firm of Foley and Lardner in Washington, D.C. While at Foley, Professor Robinson was an adjunct professor at the George Washington University School of Law. And before joining Wake Forest, Professor Robinson was an associate professor here at SMU Dedman School of Law, where he was a founding co-director of the Sci Center for Law, Science, and Innovation. From Keith. To his left is Sari Mazurko. Sari is an assistant professor of law. Can y'all hear me now? Okay. Sari is an assistant professor of law here at SMU Dedman School of Law. Her teaching and scholarship focus on law, technology, and intellectual property, and the social, political, and cultural issues associated with digital technologies, include information markets and creative expression. Professor Mazurko has a BA in government from Georgetown University, a JD from Stanford Law School, and a PhD from Yale University. Before beginning her PhD, Professor Mazurko worked at the law firm of Covington and Burling and clerked for the Honorable Thomas L. Ambro of the U.S. Court of Appeals for the Third Circuit. Professor Mazurko joined the faculty of SMU this past fall after finishing her PhD. And then on the end there, we've got Swantao Wynn. Swantao is the Pendleton, Miller, and Dale Chair in Law at the University of Washington School of Law in Seattle, Washington. Her scholarship focuses on the intersection of intellectual property law and commercial law, including banking and commerce. Professor Wynn is a BA in biology, sociology, and women's studies from Oberlin College and a JD from Northeastern University School of Law. After law school, she worked for the law firms of Freed, Frank, Harris, Shriver, and Jacobson, and then Pryor, Cashman, Sherman, and Flynn in New York City. And before joining the University of Washington School of Law, Professor Wynn was an associate professor at Texas Wesleyan University School of Law, now Texas A&M University School of Law, a professor here at SMU Dedman School of Law, where she started this very conference, and a professor at Indiana University McKinney School of Law. Welcome, everyone. So, past 20 years of intellectual property, obviously there's been a lot of development, but I think it's not too much of a stretch to say the biggest thing was probably the American Invents Act. You know, we had the creation of the PTAB, IPRs, CBMs, et cetera. So I'm going to start with Keith. So what do you think the biggest effect of the AIA has been on patent law today?
Well, so thank you for the question. And just before I start, I just want to say congratulations to SMU on 20 years again as being a part of several of putting these together. I know how much work goes into it. So congratulations, Professor Taylor, on this. So I think you have to start with, and we're talking about the past to the future. I think we have to start with some of the fears, right? So one of the things that comes to mind is moving to a first inventor to file system. and some of the fears that people, and I remember being in practice at the time, and sort of everyone thought, oh, this first inventor to file system, this is going to be the end of US patenting as we know it, right? How are we going to adjust to the system that the entire world was using at the same time? And I think those fears were dismissed rather easily. What I will say, I think, is you obviously have to look at the PTAB and the system that was created and the thought that went into creating the PTAB, creating a system that was intended to move these patents quickly through the patent system. So I think the PTAB, the system, and the jurisprudence that has come out of that, all the way up to the Supreme Court, the jurisprudence that's come out of that has been a unique outcome from the AIA. And when you look at now, if you go on the USPTO website and look at all the precedential opinions just from the PTAB, it's created its own sort of body of law that you have to keep up with alongside the other laws. So I think it's created a opportunity for, if you look at from a research standpoint, it's created opportunity for researchers to really dig in and look at the outcomes there. It's created opportunities for our students to be involved in a unique practice area. And I think it's created opportunities for practitioners. Now, whether or not it should continue in the same vein is a different discussion. But for me, I think if you just look at sort of the PTAB, I think that was sort of the biggest impact that the AIA had.
What do you
I
think?
chime in at that one. So on with what Keith, well, first of all, before I say anything, thank you and congratulations to Professor Taylor and to all of you in the rooms who were my students and also my colleagues. This is a welcoming home for me. So thank you so much for all the big hugs before the conference today. I am delighted to be home again. And so with respect to the AIA, and I still remember vividly in this space that when the AIA came about, we immediately had a conference. If you remember, with a lunch talk, David Taylor, Keith Robinson, Sarah Chan, and we talked to the students about what the impact the AIA will have. One significant thing, so looking back in the last 20 years, along with what Keith said in the PTAB, is that the decrease in the patent litigation. So the traditional patent litigation we have seen across the country, there's an increase in number. However, the PTAB litigation has increased. And so which creates a very exciting space in IP law and particularly in Texas practice. And I think that looking back, we see the excitement of the AIA and opportunities that have created in both for new theories, as we've seen with PTAB, but also that how we refocus on what are some of the key issues in patent law itself, because in the prior 20 years before that, it was quiet. If we look at patent laws in the 70s, in the 80s, in certain cases in the 90s, but clearly in the last 20 years, how the AIA's impact bleach into the other areas of patent, the development of patent law, and that's I felt also significant.
Okay. Well, sticking with you, Swantal, is there a change that we didn't anticipate? Like, what's the biggest surprise we've seen as a result of the AIA?
And so for me, that it had to be related to not just the AIA in particular alone, but how it leads into the space of that create more jobs for patent lawyers, one thing, and also that the race to obtaining and applying new applications. So clearly we have seen the increase in the numbers of patent filings in this country, and also that continue to situate the United States as one of the key places globally to obtain patents as well.
Can I just add one thing to that? I think one of the unanticipated things that came out that was really good are the regional offices. And so I think that is, I remember when the newest regional office was not yet announced, and I remember there being a lot of buzz in North Carolina about wanting to have a regional office in North Carolina. And I think that's allowed the USPTO to increase its outreach. And I think that's been incredibly impactful. And I know that I have several colleagues sort of working on looking at the research impact of having regional offices in those areas. and what has been the impact on patenting activity in the surrounding areas. And I think what we'll find is that overall, those offices have increased awareness in IP issues and increased patenting activity in those surrounding areas.
And it also put Texas on the map clearly, because that if you remember the lobbying efforts that the practicing bar at that time, Lisa Evers and many of us tried to lobby USPTO, and we had David Capos came down here to SMU for a meeting as well, and also meeting with the practicing bar. We say Texas is it. Texas is the place that they should consider. And I remember David Capos articulated that, yes, there's liquidity, there's high liquidity here in Texas, and also the IP activities, the invention activities going on in Texas. Clearly, the regional office that propelled Texas, and so therefore, USPTO not to look to the East Coast or the West Coast, but right here in Texas. And so I think that it shaped the conversation, not only that in patent prosecution, but also in patent litigations as well. It's incredible.
I'll add something here. I think one thing I think is important too, and this is not to kiss up to our friends in the audience, but it expanded the talent pool of people who could work for the PTO. You know, it wasn't just practitioners in the Washington DC area who wanted to be judges or examiners. Now we've got people in Dallas, we've got people in the Bay Area, we've got people in Denver, and I think that has really improved the quality of the PTO too. So you mentioned litigation. So we've been focusing kind of on this, the offices and the PTAB. Like how has the existence of the availability of IPRs and things like that changed patent litigation? So Swantelle, you want to take that one too?
I don't want to dominate it. Let me deal with the piece and then I jump in.
Okay.
Well, I mean, I think it's created a, there are people that specialize in, coordinating litigation where you have, parallel litigation in district courts, and you have IPR. So I think now when you're considering your litigation strategy, it's definitely something that you have to take into account. Again, I would say that from a research standpoint, we see sort of the behavior of the patent owner versus the behavior of the alleged infringer, their incentives and their behavior changing a little bit because of the existence of these PTAB procedures. So I think litigation looks totally different than it did prior to the AIA. And again, not to say that there are not issues with the procedure, but I do think that it is made it a little bit, trying to put this nicely. I think it's made it a little bit more interesting to see how patent litigation plays out when you have these procedures available. And if you look at sort of the behavior and the activity that happened, especially with the covered business methods patents, did we get rid of these quote unquote bad patents? Did we flush them out of the system? I think I think most people will say yes. I think there's some debate as to that. I think overall it's been a good system with a few exceptions for bad actors. And we've seen the patent office try to adjust to that and account for that.
So in terms of patent litigation, I look at the last 20 years, what we have seen some major issues here that on the one hand, we see the funding for patent litigation. It's the business model in of itself, and legally, the kinds of investor bank fundings for patent litigation. We have seen not only in the IP state, but the IP states that give birth to patent litigation that the funding of it has become global. So you see that UK investors invested in litigation, back in litigation itself. And if you look at where that idea came from, it came from in the early days of patent litigation. When I say early, within the 20 years period of time, And here in Texas, and of course, we will hear later on with the Eastern District of Texas South, but we can see clearly that patent litigation, and because of the cost of litigation and who's backing the litigation and investors in this particular space as well. And then that's one hand in terms of funding the patent litigation. On the other hand, we also see that the Supreme Court of the United States in the last 20 years they have become so incredibly active in taking on, you name it, for how many cases in 101. And constantly in the last 20 years, almost like either you live in joy or you live in fear. And that the Supreme Court goes to tackle on another 101 issues itself, 112. So we can see there's so many cases. So we'll see about, when we talk about patent litigation, we look at several issues that impacting patent litigation.
So we spent a lot of time on litigation. I know we're boring Sari here, but let's stick with it a little bit longer. I would talk a little bit more about just the PTAB and IPRs in general. And Keith, thank you for mentioning CBMs. I think my boss would be upset with me if I had let the panel go without at least mentioning CBMs, which I don't know if people know those were basically specific to the financial industry. They were sunset a couple years ago. I might have some questions for those. Why not bring them back? But sticking with IPRs, one thing we did change was the claim construction standard for IPRs. We went from the broadest reasonable interpretation to basically the district court claim construction standard. How did that change the practice of IPRs, if at all? Keith?
Yeah, so I think the short answer is, so if you look at the research, the outcomes, that you don't see a drastic difference. I think what it did for practitioners is increase the predictability, and that's really what you want. As you're counseling clients, you can say to them, look, this is the standard, this is how our claims are going to be evaluated, and this is how we think we should go forward. And so now you're not dealing with two different standards. So I think that change was important for predictability.
Speaking of predictability, I guess one thing that people complain about as being unpredictable is we still have discretionary denials, and which affects not only the IPR proceedings but also parallel litigation that might be out there. Swan Tao, any thoughts about discretionary denials? Are these a good thing? I've actually been a lot of complaints from the industry about this. What are your thoughts?
My thoughts on that one thing. Because of my work outside the United States, I constantly compare the United States to places outside the United States, and whether that's what we've seen in terms of we allowing the discretions here compared to other places outside the US, that whether they have the same type of discretions available or not. I do support the discretion because it allows, I don't like to use the word innovation, but allows the kinds of flexibility, and that's important. That's really important for the development of the laws and the practices. So I'm in favor of it. Yes, there's some level of unpredictability, but I think that when we're talking about development, there's always some uncertainty, and it's welcomed.
And one last question before we move on to a non-patent subject. I did want to talk about CBM. So we talked about getting a lot of bad patents off the books, things like that, not just in CBMs, but also in IPRs. But we sunset this proceeding. Why not renew this proceeding? Was there an issue with it? Did something not work? Why do we let this proceeding kind of go abandoned?
Yeah, I think that what the Patent Office is really good at is piloting ideas. And I think the idea behind the covered business methods review was we're going to do this for a couple of years to see how it goes, see how it works. Now, all indications are that it went well. I don't know why, I don't know what's going on behind the scenes to revive it. But I think the intention was that if we have this for a short period of time, all the important cases that we need to address, we're going to be able to address in this short period of time. But, I think that just speaks overall to how the USPTO is structured and how it runs these sort of little experiments or pilots. And, what that does is, what that accomplishes within the system. And so I wouldn't be against it being revived, but I'm sure that there might be, maybe Director Shimabuku can speak to why it may not be coming back.
But before we go on that, I just want to echo something here. When we talk about patents and the fact that we have this kind of experiments to allow new innovation become access. And sometimes we lost track of what does that mean? I mean, it's enormously important to allow new patents, because at the end of the day, that's what the products of the company, that's how they're able to get funding. That's how they be able to hire new employees and also expand. So it's enormously important when we look at globally here, what are we producing? And we producing IP. That's new corporate properties and access, and then enabling the funding, enabling the economy to grow. And so I'm always in favor that the U.S. Patent Office experimenting, yes, within the constraints of 101, within the constraints of the Supreme Court ruling itself. But at the end of the day, is that how are we, the bigger pictures are how are we producing new property, creating new value here, and not only for the corporation, but also for the nation, and also for the competition between the United States and other countries as well. So the big pictures always should be part of the thinking of the policy.
Thank you. So Sari, got a question for you now. So obviously the AIA is not the only area where we've had some changes in the law. We also have the Trademark Modernization Act. So what effect do you think that will have on the practice of both trademark law, and it's got some copyright stuff in it as well?
So the Trademark Modernization Act took effect in December 2021. So it's been only about 2 years. And it allows third parties to submit evidence to the trademark examiner that are relevant to grounds to refuse registration. So that's a major change. It's basically like an ex parte submission. There's a rebuttable presumption now of irreparable harm when a trademark holder is seeking an injunction. Whereas before it differed based on the jurisdiction you were practicing in. The third thing is it instituted this initiative to clear the trademark register of registrations that were based on inaccurate or false claims. And to that end, the USPTO created a new rule, 2 new ex parte expungement and reexamination proceedings to cancel unused registered marks. That method is cheaper and faster than a contested cancellation proceeding at the Trademark Trial and Appeal Board. So those practices, like how practice has changed, is still underway, but it allows broader opportunities for people to submit evidence to these refusal and cancellation proceedings. And it should speed up the process significantly and help save costs as well.
Well, Keith and Swan Towns, you're more on the patent side. So obviously, on the patent side, we don't have this presumption of irreparable harm. We now have for trademarks. Why do you think that is? Like, why is it appropriate in the trademark context, but not in the patent context?
Well, because the Supreme Court says so, not because I say so. So if it was my way, if it was my way, I'm not going to have eBay versus my exchange, because I look at what Germany, what China, what other countries doing, that in those countries, they have automatics. If you're able to prove infringement, it's automatic injunction. Why we in the United States that the Supreme Court decide to go the opposite direction? And so I'm looking back at there should be some study, long-term study, to see that whether it's have been helping us or hurting us. The fact that we eBay versus my exchange, and clearly the trademark bar with the powerhouse like IMTA, they able to lobby Congress and make sure that when they have the law changed 2 years ago, that they rejected eBay versus my exchange. So look at it globally. I think that we out of touch with the global communities itself, i.e. that we are not viewing patents as the same kind of value that Germany's or China's place on patents when we look at eBay versus my exchange.
One of the other interesting things about that is, so in patent law, we've had third-party oppositions for some time, but they're not, they're not used very often. And I'll be curious to see whether or not in the trademark context, you get more participants than we get with the third-party oppositions in patent law.
So another area of law that's kind of been, I guess, neglected for a while is design patents. I know I was a clerk at the Fed Circuit when Egyptian Goddess came around, and I remember telling someone there that no one cares about design patents. Clearly I was wrong. But so since then, though, obviously, we've had cases like Apple v. Samsung, which were predominantly design patent issues. And now I guess we're getting a new design patent bar. With this new emphasis on design, why is there this new emphasis on design patents? Swantel, you want to take that one?
Sure. When we look at the cell phones, right? Who want to have a cell phone that will be so squarish? No, you want the corners rounded. It's organic. It looks much more interesting, sexier, of course, right? Because if it's angular, then that's not going to work quite well in our pocket. So design matters. And so we've seen that the movements in consumer products, if we look back in the 80s, the 90s, and we see the rise of Macintosh, Apple with Steve Jobs, the emphasis on designs. The more focus on consumer products, design matter to the consumers itself. And I think also that because if you look at back in the 80s, there was a very uncomfortable space that's when you have innovation that cannot fall into the utility patents, cannot fall into the copyright protection. So where can you find the niche then? Where's that niche going to be? And also because of consumer product focus, so design matters significantly. So I think that's why it gives birth to, I'm not surprised at all here that gives birth to the new design patent bar itself.
One other thing to add about that, I think the Patent Office has been increasingly interested in the diversity within the patent bar, who practices before the USPTO. And I've had a lot of thoughtful conversations with Deputy Director Brent about this issue. And I think that one of the reasons or rationales for creating the design patent bar was the hope that it would expand the opportunities for women, underrepresented persons to practice before the bar. So, it remains to be seen what that might look like. But I think part of the USPTO's rationale was that, trying to diversify the patent bar a bit.
And may I just chime in there? And also, again, when we talk about IP law, we look outside the United States. You see countries in China, in Japan, there's still a very strong focus on design patent protection. Same in Vietnam as well. And so in those countries, what I have seen that in the last few years, for an example, the banks willing to provide loans against patents, including design patents. And so we're talking about during the pandemic, for an example, $33 billion in loans by banks in China backing any companies have IP, i.e. patents and design patents. And so clear the mindset of many nations now that we are moving from physical labor to intellectual property based production and design patents make it easier for companies to be able to obtain protection, and which means not only just protection, but obtain property. And then the property then can be used for financing itself. So that's why you see outside the United States, there have been a strong embrace of design patents types.
So kind of moving to another topic here, but I think probably the last area where Congress has acted in the last 20 years is in the trade secret area. We've got the Defend Trade Secret Act. Prior to this, we had trade secrets, we had state causes of action and things like that. So Keith, why did Congress feel there was a need to have a legislation at the federal level on
Well,
trade secrets?
Well, one of the things, so when we talk about trade secret, before the Defend Trade Secret Act, when I was talking to trade secrets with my students, one of the things that became clear is that each state had different rules, right? And depending upon what state you're in, the definition of a trade secret might change a little bit. And so again, I think, one of the things here is some predictability. We wanted a federal cause of action. The Defend Trade Secret Act also, defines what a trade secret is at sort of the federal level. And so I think to a certain extent, it increases predictability for the owners of trade secrets.
I will say I recently was following a case that was filed in Georgia under the Georgia Act, got removed to federal court. They added a claim under the DTSA. It got transferred to Northern California. And so we had a Northern California court, hearing case on the Georgia Trade Secret Act.
With the trade secrets, if you think about why do we finally have the federal trade secrets law, I will also argue that in the last 20 years, because of the 101 decisions, the 101 decision from the Supreme Court that was so hostile to many companies, i.e. if you are new startup, and if you in certain sectors, like in the software sector, you cannot obtain patent protection. So therefore you look to trade secrets law. And so the trade secret law gives you that kind of layer of protection. And so, which means from the funder perspective, if you are VCs, if you're going to make a decision of whether you're going to provide financing routes to startups at all, and when you ask them, do you have patents? They say no, because of 101. What do they have then? Trade secrets. So pretty much when you look at in the West Coast, that's because where I'm based right now, that every startup relied on trade secret law because they cannot get patent protections. So that's why that to have the federal law, a uniform trade secrets law, is so important to these new startups for their funding as well.
Okay. Well, we've talked about patents for a lot, so I don't want Sarah to get bored, again. So let's move to some of the recent developments in case law. We talked about the Supreme Court getting involved in things. Certainly on the patent side, you said you people are either very happy or very upset. I know when I see it, I just kind of like, oh boy, here we go again. But recently they've gotten involved more in copyrights and trademarks. We had a number of cases. So Sari, recently we had the Jack Daniels case. So where the Supreme Court held that parody products can still run afoul of trademark law. So what does this mean for parody products and things like that?
Yeah, so it's been a major shift. The case is Jack Daniels versus VIP Products, decided by the Supreme Court in 2023. And leading up to that case, for probably 10 years or more, we saw the ascendance of what's called the Rogers test from the case Rogers versus Grimaldi in the Second Circuit. And the Rogers test protected expressive works from being subject to a likelihood of infringement analysis under trademark law. Instead, they were subject to a more lenient standard. For expressive works, they needed to use trademark in a way, the underlying trademark, a third party's trademark, in a way that was artistically relevant to their own work and in a manner that's not explicitly misleading as to source. So it was really hard to not win when the Rogers test applied. And then in VIP Products, the issue was a squeaky dog toy that parodied Jack Daniels bottles, and it was called Bad Spaniels. And it said Bad Spaniels on the bottle. It said Bad Spaniels on the hang tag attached to it. It was sold under that name. And the Supreme Court held that the Rogers test does not apply when a parodist is using a third party's mark as its own mark in some way, even when its own mark is a parody of that third party's mark. So that was a major shift in the application of the Rogers test. And I think since then, it's made lower courts, appellate courts even, hesitant to apply the Rogers test when it could have otherwise still applied following the VIP Products. So the two recent cases here, are Vans versus Mischief in the Second Circuit, decided in 2023. And that concerned this design group, design group / artist collective Mischief made a limited issue of sneakers called Wavy Babies that are a parody of the Vans old school sneakers, which are pretty iconic in their look. The Mischief Wavy Baby sneakers were effectively unwearable. Like you could put them on your foot, but the inner sole is wavy. So it's extremely uncomfortable and difficult to walk in. It's not meant to be worn as a shoe. And the Second Circuit held that the Rogers test would neither apply to the shoe itself nor to the box that it was shipped in that parodied the Vans shoe box. And it would be subject just to a regular likelihood of confusion analysis. But that didn't necessarily follow from VIP products. That's an extension of VIP products. And then only last month, the Ninth Circuit decided the case Punch Bowl versus AJ Press. So AJ Press had a registered trademark in this name, Punch Bowl, and two reporters from Politico spun off and decided to create their own blog that was kind of like a gossip press about what's going on behind the scenes in DC. And they called their blog Punch Bowl News, and they registered a domain name for their blog, Punch Bowl News. And the Ninth Circuit held that the Rogers test did not apply to protect those reporters / bloggers in using Punch Bowl for their blog. And that's a major extension of VIP products, and it conflicts with the Rogers test as it was created by the Second Circuit, because the Rogers test concerned a title of a movie and a title of a blog, even if it's used in a domain name also. I wonder how materially different that is. So what we've seen is the Rogers test went from being really ascendant for a number of years. Post VIP, it's on the decline as courts seem to hesitate to apply it.
And don't we have a restaurant in town called Punch Bowl Social? Are they worried about getting sued?
They probably should be.
So
Can I ask, just, so before the Jack Daniels case, there were a lot of pundits that said that their fear was that the Supreme Court was going to get rid of the Rogers test, right? But it seems like that's kind of what happened effectively at the lower courts without the Supreme Court directly overruling it. Is that your thought or your view?
I mean, now that the Second Circuit and the Ninth Circuit have issued those decisions, those are the leaders generally in trademark doctrine at the appellate level. I would say that it has been the practical effect of VIP products, even if it wasn't the intended effect by the Supreme Court.
So what's the parodist supposed to do now? I mean,
Don't laugh.
License, right?
yeah,
License.
license.
And is that going to happen? I'm not so
$100
sure.
approach basically, and get your license before you put out your song.
Yeah.
So, okay. So the other big case we had was obviously the Andy Warhol versus Goldsmith case, involving the Prince lithograph, I guess. In that case, I guess the Supreme Court really focused on like the purpose and character of the artwork. You want to tell us a little bit more about that? And then to the extent they did focus on like the purpose of an artwork, how can that be defined? Or how can a court figure out what the purpose of a piece of artwork is?
Yeah. So I think, so the Goldsmith versus Andy Warhol case concerned fairly famous photographer, Lynn Goldsmith. Her portrait of Prince was used by Andy Warhol while he was living to create a series of lithographs of Prince. It was only licensed to create one lithograph for Vanity Fair magazine, but he created a series. And then after he passed away, his estate licensed one of those basically unlicensed by Goldsmith lithographs back to a commemorative issue of the magazine about Prince again. And the Supreme Court, in interpreting the first factor in the fair use analysis, didn't focus so much on the transformative aspect of Prince creating the lithographs based on Lynn Goldsmith's photograph of Prince, which is where the focus was placed traditionally. It was on how the follow-on work used its source work, whether that was transformative and a fair use. But instead now the focus has shifted into how that follow-on work is being used, specifically whether it's being put to a commercial use. And this is going to be a really hard standard for lower courts to apply, this idea that if a follow-on work is being commercialized in some sense, licensed to a magazine or otherwise commercialized, maybe there are advertisements for it or something like that, and that's enough to qualify. then they don't benefit from the first factor of the fair use analysis. And it also conflicts with the Supreme Court's recent opinion in Oracle versus Google, which was decided not too long before this Warhol opinion, where the court didn't really seem to care about the fact that Google was making a commercial use of the Java APIs in its own API package. That wasn't a major factor because it found that Google's use was so transformative in allowing the Java programming language to kind of flow through Google's Android platform. So I think it's kind of incomprehensible because Warhol didn't overrule Oracle versus Google. So that's left to lower courts to figure out how heavily to consider transformativeness versus commercial use.
Let me jump into that after Sari's remarks there. So I look at the Andy Warhol's case, and it's because that's decision 7-2, right? 7-2. And so you have Kagan and Robert, from two different political extremes, as we say, and then yet they was the dissenting opinions in Andy Warhol's, the foundation's case, versus in Google, in the Google case, you have Thomas and Alito, the two justices in the dissenting opinion. And so if you put it together and ask ourselves what's going to happen next when we talk about what's the next 20 years will be like. And so we see that if you look at the fair use of 4 factors up at the Supreme Court and tracing the type of cases that the last time that we had major fair use before these 2 cases itself. So we have the Justice O'Connor's decision in Harper Rowe's case. But then we look at how the decision in Google is going to foreshadow what is going to be up in the Supreme Court in the age of AI. Is that because that the Warhols we are focused more on the commercial because it's artwork, or versus in the tech space with the Google decision that the court's more willing to favor more on the transformative aspects of Google's behavior, Google activities itself. So I think it's quite telling. And then it's going to be fascinating in terms of the next Supreme Court decision on fair use.
So speaking of fair use, I guess we still have some pending cases that are out there too. We've got, we got some NFT litigation. We've got some employers suing unions. So Sari, like in that kind of stuff that's still pending, like where do you see those cases going? Or obviously it's a lot of stuff is up in the air. Like, what do you think might happen in those cases?
So we have some, at least early resolution in the NFT litigation. These are trademark disputes. Nike versus StockX is still underway. Hermes versus Rothschild was decided by the District Court in New York, and it's being appealed to the Second Circuit. It'll be interesting to see how they interpret VIP products and apply it in that case. I think our concern as trademark scholars is, will they apply an overbroad interpretation of VIP products and hold that Rogers doesn't apply to the use of a trademark within the digital image aspect of an NFT? Or will they apply it in a more limited way when it's being used as it's titled, it's being sold as, a trademark, Meta Birkins, the fact that it used Birkins in the name, maybe that's the issue rather than the fact that it contains a digital image depicting a Birkin. So there are 2 ways courts could go there for Hermes versus Rothschild, but I think we see where it's going based on Vans versus Mischief. That it'll hold that the Rogers test doesn't apply to the depiction of a Birkin within the digital image aspect of the NFT. The union trademark litigation is fascinating. Ultimately, I think it's going to settle. So by way of context, Trader Joe's, Medieval Times, and Starbucks are suing their unions that are forming because the unions of their employees want to use aspects of either the name of their employer or, color palettes they use, the shape of their logo, some things that depict their affiliation with their employer, and they're suing for trademark infringement. And this is a major, new kind of trademark litigation. I think if it settles, it'll do us a disservice because I do want to see how it plays out. And I think the most interesting aspect of that is it doesn't really involve consumer confusion, right? And that's kind of trademark law's bread and butter. So it involves two totally different groups, a union and an employer, rather than two competitors, would-be competitors, or the likelihood consumers will be confused about where their groceries or medieval javelin competitions come from. And the other major decision we're waiting on is In re Elster. That's the current case in front of the Supreme Court on whether the bar to registering a trademark in a living person's name without their consent is constitutional or not under the First Amendment. And the court heard oral argument recently. It seems they're leaning in favor of the bar's constitutionality, which is a departure from the two recent cases in Mattel versus Tam and Iancu versus Brunetti that held that other statutory bars to registering scandalous and immoral or disparaging marks were unconstitutional.
Let me situate some of these cases in the broader context. I mean, we ask ourselves why unions are big issues now. I mean, we saw with Hollywood strike with unions, right? And then we just saw just this week, Alaska Airlines, the flight attendant voted. They voted that they would go on strike. And so we can see that unions matters now, given the age of AI that we are in. So from Seattle, the land of Starbucks, that's clearly a concern from the trademark owner perspective. Is out that they want to control their famous mark, but at the same time, that at this particular juncture, is out that many employees that we have seen, for example, at whether we're talking about at Starbucks or Trader Joe's or in Hollywood itself or at Alaska Airlines, that using aspects of the trademarks for identification purpose matter to them because it's about their own identities. So the employees have their own identity. They employ at a company and they work together. They are not using the trademark in the trademark sense itself. And also in the larger context of why union organization at this moment in the age of AI. And so situating that, I think that therefore the companies itself probably most likely will settle these cases because the negative publicity that they going to generate or have been generating, not only that in the workplace, but also among the law students. I mean, at the University of Washington, the students themselves are up in arms and they do not like to see what's going on with Starbucks or Trader Joe's.
Well, you mentioned AI there, which is what I want to turn to next. I mean, we can't have a CLE here in 2024 without talking about AI. In fact, that's the one thing David said we had to talk about. So obviously earlier this week, the PTO issued a notice regarding AI. I don't know if anyone on the panel has had a chance to read it. Has any thoughts about it yet?
I have a few thoughts. So with respect to artificial intelligence, I think the first thing that we have to understand and be clear about is defining what artificial intelligence is, right? And I think there's been a lot of, because of OpenAI, because of ChatGPT, people think that that is artificial intelligence. But artificial intelligence has been around for quite some time, comes in many different flavors. And so one of the things that I've been sort of concerned about in my work is making sure that we don't have these sort of blanket prohibitions on the use of artificial intelligence because, your grammar checker in Word could be considered artificial intelligence, right? And so, one of the other things is that a lot of accessibility tools use artificial intelligence. And so I think we have to be very nuanced in thinking about what artificial intelligence is and what outcomes we want to, what are the outcomes that we are hoping to achieve by placing rules around artificial intelligence. And so I think the first step is, to understand, what it is and how it's going to impact our work going forward. I don't think that, within the next 10 years, you're going to see anybody that says that they're not using artificial intelligence in their day-to-day work in some form or fashion. And so if that is going to be the reality, then we have to understand, is artificial intelligence any different than me having a calculator with me all day and doing calculations with the calculator? And what rules are we going to put in place? I think the USPTO has been very thoughtful about that. I think the overall goal should be that we want to continue to promote innovation and not stagnate it. And so how can we place rules around it, guardrails around artificial intelligence to do that?
And so when we look at artificial intelligence in the law, I remember my old professor, Donald Berman, he taught artificial in the law back in 1992 when I was a law student. Can you imagine it? Artificial intelligence and the law in 1992. That was the class offer at my old law school in 1992. So it's been around with us for quite some time. But I think that because of open AI and the generative AI that we saw, and then the whole world itself jumped on this awakening that, oh my gosh, this artificial intelligence is taking over our life. I do agree with Keith that true that we going to, and we are doing it already, embracing artificial intelligence. But there's some major issues, obviously, is on the table right now. It's very concerning to all of us, right? Because as of yesterday, for example, OpenAI released Sora, S-O-R-A. Sora is Japanese word for sky. And Sora programs can generate incredible videos in matter of seconds. And you look at the pictures of the new videos itself. But if you look carefully at what exactly the Sora program's doing, is that it's go from the text prompts to generate the videos. But if you look carefully at the text prompts, it's opening up new opportunities about how are we training our law students at this law school or elsewhere, or how we training our new young associates at the law firm, that you see that prompt engineering is going to be one of the key aspects of it for using generative AI or general AI itself, is that prompt engineering requires what? Requires that you need to know the law well in order to be able to ask the precise prompts. And so we doing in our law school that we teaching the student on prompt engineering for contracts drafting, prompt engineering for IP license agreements, prompt engineering for the memos that they're writing. And so you can see the opportunities that generative AI provide to us. Either we're going to embrace it, and we should embrace it fully. But on the other hand, however, that any simple prompts, you will see that right now clearly violating copyrights. No question about that at all. Okay? And so which means that what's the guardrails? What the guardrails then? What the guardrails that the Copyright Office is going to have, or Congress will have, or none at all? Because clearly is that copyright violations happening, and OpenAIs and other AI programs are not disclosing how they train their models at all. And if for those of us in the room that have gray hair, if you remember what is fair use, and so whether that OpenAI and Microsoft, whether their use is fair use or not, so go back to Google versus Oracle itself. Is that fair use in terms of what OpenAI and Microsoft doing? We don't know at this moment how they training their programs, how they train in Sora. They don't tell us, but clearly the guardrails must be some kind of disclosures. But then if we ask them to disclose, then they will say it's trade secrets. It's trade secrets. They're not going to disclose that. And so you can see that it's a very complex matter that IP, both copyright law and trade secrets law, is right at the centers of it.
Yeah, I think it's beyond denying that large language models make copies in the process of studying whatever they're studying. And the people I know who are lawyers for AI companies think that they're on the right side of the law. They equate large language models to, going to a museum and viewing the artwork and learning what a Matisse looks like and what a Da Vinci looks like, and then trying to do it your own way, whether it's in the style of Da Vinci or whether it's a mashup or something that draws on that work in some way. It's learning, and learning is a use that's not a copyright infringement. You're able to use a work that you lawfully own, And on the other side, authors want a very strict interpretation of copyright law, authors, artists, creators, that because a copy is being made, that it should not be a fair use. But I think it's really the Oracle case that'll be interesting to see how it plays out here, because the court seems to be pretty tech friendly and doesn't want to get in the way of innovation. But there is a lot of zeal on the authors and creators side in this dispute.
Well, it's funny, I just think talking about like, viewing a painting and doing your own version of it. This kind of reminds me of the Blurred Lines, copyright case we had a couple years ago, which the two songs did not sound the same to me, but yeah, they had a similar vibe. Apparently that was enough there. Is that going to be the case in the AI context?
But I also see that if you just type in a very simple prompt and you ask if, if those of you who have children and SpongeBob's, the square sponge with wedding pants, if you just ask, if you just type a simple prompt and it will come out exactly like that, exactly as SpongeBob. So if you are the creators of that, would you like it? That somebody took it wholesale and not paying you a penny for that at all? I mean, we are talking about that, the LM models, we're talking about hundreds of billions of dollars, and not only in the United States, outside the United States as well. I think that in many ways that the artists themselves and the author themselves, and that they do want to have a share. And that's why OpenAI and Microsoft enter into various license agreements with various copyright holders, but then the other copyright holders that OpenAI and Microsoft are not giving them a fair share. That's why they resort to litigation itself. So I think that on the one hand, we are for innovation, but on the other hand, is that there's certain kind of fair shares that need to be paid to recognize the work of the artists and the authors, because all of us in this room, I mean, we don't mind that people text our work, but there's gotta be some kind of attribution. At least they gotta have attribution for that, because without that, where are we going? I mean, in many ways, that our founding father, when they created the copyright clause in the Constitution itself, hinting at what? Well, there's a level of creativity, you have to recognize it. And so therefore, some kinds of attribution or some kinds of fair share must be at the table itself. So when you look outside the United States, Australia, in the age of AI, Australia passed a law that's called the News Act, and requires essentially that AI companies that's making copies of all of the copyrighted news have to pay under copyright law, but this is they call the News Act, Australian News Act, and pay the copyright owners when the OpenAI or AIs use those contents to train their models itself. So there gotta be somewhere something's here. Otherwise, that we are turning the copyright laws on its own head as well.
The one other thing I'll say about this, and this speaks to the inventorship and authorship issue that I'm fascinated by and it'll be interesting to see, is, I think this is more of a cultural thing, is whether or not we care if you use AI to create a new work, right? And so there have been a number of news stories about people winning, people winning art contests, where the AI has generated the art. I think there was a novelist, a woman in Japan that recently won a novelist award, and she admitted that she used AI to help her write the novel. And so I think we have to kind of decide as a culture whether or not we think that using these tools to create new works is acceptable or not. And it'll be interesting to see how we come out on that. And I think a lot of that will, will involve sort of these legal disputes that are going on now. You just ask yourself, would you read a book on Amazon that was wholly written by AI if you knew that a human person had nothing to do with the book? Whether or not you enjoy the book or not if you don't know. And so these are sort of interesting questions that will play out over the next couple of years.
On that note, it's going to be really interesting to see the implications of the Copyright Office deciding that it won't register works that are created by AI. It also goes to the equities, because in a sense, it incentivizes like movie studios, for instance, to have humans write their scripts rather than AI, because it's very important to them to have copyright protection all the way through, from script writing to acting to, video generation, because if they don't have copyright protection, then their work falls into the public domain and it could be copied freely, et cetera, derivative works based on it. So that really limits their revenue streams if they rely on AI heavily, or at any juncture, it weakens the copyright that they might have. So it provides greater incentives to hire humans and have humans participate in the process in a really meaningful way. On the other hand, some find it disturbing that the Copyright Office won't protect AI-generated works, because it could involve a lot of creative labor on the input generation side, and selecting and curating whatever image or video the AI generates, that people want to have protection for their use of AI. But people want to have jobs for when they don't use AI and they create works on their own.
Right, and then then follow up with that, in the age of AI, do we still need copyright terms that life of the author plus 70 years or 95 years, 120 years? And that's enormous amount of time, given that AI can generate it instantly. So it's almost a question, it's almost there's issue related to the absurdity of it as well, because when you look at such a long duration of that, do we need such long durations in the age of AI, instantaneously creating new works? So there's a lot to look forward to.
Okay, and at that, we're at time. We're at 10:15. So thank you, panelists. Thank you, everyone. And I guess we'll take a break.
All right, and we're on break for 15 minutes. We'll start again at 10:30.
Some point in